My immediate temptation, given the date, was to come up and spout about 30 minutes of nonsense and then say April Fools. I'm going to avoid that temptation. You might still decide that what I say is nonsense, but if it is, it's entirely unintentional. The other thing I should mention before we actually get to the presentation is that I wrote about half of this speech while sitting in the airport in Baton Rouge. So if there's any Cajun twang to it, it would be because of that. I also felt a little bit inspired to be writing about dubious government activity while sitting so close to the state capital of Louisiana. But instead of giving you 30 minutes of nonsense designed at nonsense, I'm actually going to be giving a new version of a presentation that I gave back in November 2017 that was on the current state of redistricting at that point, and it followed up on a series of columns about the redistricting scorecard. This was the first one that appeared at carolinajournal.com back in May of 2017. There was another one after that that gave an update on the redistricting scorecard. If you want to go back and see what I said at that point, just go to carolinajournal.com, do a search for redistricting scorecard, and both of those columns will come up. This time we're going to simplify things a bit because at that time there were about 7 different cases that were in various stages of the court process. This time I'm going to simplify by breaking down this presentation into 3 parts. First, the federal court case, then the state court case, and then, as a third part, kind of a coda, the push for redistricting reform that's ongoing this year. So let's first talk about the federal court case, the one that Donna just referenced, that the U.S. Supreme Court heard oral arguments in last week, Rucho versus Common Cause. For those who don't know, that's Rucho. Former State Senator Bob Rucho, who is now a member of the UNC Board of Governors. He was the head of the state Senate's redistricting efforts at the time that these lawsuits were filed, and hence his name was the one that ended up being put on the lawsuit from Common Cause, also a lawsuit from the League of Women Voters. Those 2 suits got lumped together as they moved through the court process. The Supreme Court heard oral arguments on March 26th. We expect the decision to come out before their term ends at the end of June. This is a case of partisan gerrymandering as opposed to racial gerrymandering. North Carolina has dealt with both types of cases in the past. This one is not arguing that the 2016 congressional map that North Carolina is using is a problem because of racial issues, but because too much partisanship was involved in putting the election map together. This case potentially could close the door on a door that was initially opened in 1986. And I'll get to what that means in just a bit. But first, a reminder that what we call partisan gerrymandering today is somewhat redundant because it's basically gerrymandering. All gerrymandering has been done for partisan advantage. And so calling it partisan gerrymandering is basically just a way to distinguish it from racial gerrymandering. But partisan gerrymandering is good old-fashioned gerrymandering as it was known for years and years and years. In North Carolina, gerrymandering dates all the way back to the 1730s. If you look at the document that the attorneys for the General Assembly filed in this case, they reference that the governor at the time drew electoral districts to help benefit him and his party at the time. So that's a full 80 years, 1732 was when that happened. It was a full 80 years before this guy loaned his name to the actual practice. That's Elbridge Gerry or Jerry. I've heard it pronounced both ways. He was a founder, was involved in helping put together the Constitution, was an early political leader in the United States. And it was his 1812 election map for the state of Massachusetts that produced the term gerrymandering. There was a district in there that looked like a salamander, and someone said it looks like a salamander. It was done by Elbert gerrymander. So we've had that term ever since, that 1812 map. That was the first time this practice had a name, but as we just mentioned, in North Carolina, the practice went back 80 years before it was even named. For years, courts had nothing to do with partisan gerrymandering and whether it was too partisan or not partisan enough. But things changed in 1986. There was an Indiana case, Davis v. Bandemere, in which the U.S. Supreme Court first decided that there was a potential that partisan gerrymandering, too much partisanship in drawing election maps, could be unconstitutional. Now that case said that this could be a problem, but there was no agreeable standard about when partisanship could be too much partisanship. And so for the past 30 years, opponents of gerrymandering have been trying to come up with some sort of standard, what would be called a judicially manageable standard, in which judges could determine that gerrymandering done for partisan purposes is too partisan and thus unconstitutional. In 2004, there was a major case, Veith, and I'm not even going to try to pronounce the second name. Everyone who talks about this case calls it Veith, including during the oral arguments last week. The Veith case was out of Pennsylvania, and basically in that case what you had was at the time 4 justices who you would describe as the liberal bloc on the court decided, yes, partisan gerrymandering is a problem, it's unconstitutional, here's a standard we're going to use, and it's going to help judges throw out future partisan gerrymandering cases. On the other side were 4 justices, the conservative bloc, who said, no, this is a political issue. It's always been a political issue. Judges can't get involved. There's no way to have a judicially manageable standard. We should just wipe our hands of partisan gerrymandering cases. And there was a swing vote. Can anyone guess who the swing vote might have been? Kennedy. Anthony Kennedy, who agreed on one hand that there could be too much partisan gerrymandering, and thus it could be unconstitutional. He agreed with the liberal bloc. But he said, in this case, the plaintiffs have not come up with any kind of manageable standard. There's no way that we could throw out this Pennsylvania election map because of that. And so in terms of the practical result, he sided with the conservatives. It was a 5-4 decision, throwing out the challenge to this Pennsylvania map. But ever since that decision in 2004, the opponents of gerrymandering basically had an audience of one. Anthony Kennedy, could they come up with some sort of standard, a judicially manageable standard that would convince Kennedy, that would bring him along with the other 4 justices who had already decided there could be too much partisan gerrymandering? That's why you saw, as the cases that came to court over the past couple of years, you saw things like the efficiency gap and other types of statistical measures that were put forward as potential ways to allow judges to strike down an election map because of too much partisanship. That came to a head last year in another Supreme Court case out of Wisconsin called Gill versus Whitford. At that point, the opponents of partisan gerrymandering had thought, aha, we have these standards, the court's going to go along with this. Anthony Kennedy is finally going to go along with the liberal bloc and say, there's too much partisan gerrymandering, it's unconstitutional, it needs to go. But then the court punted. They basically decided not to address that issue. Instead, Gill v. Whitford was thrown out because of lack of standing. They said the plaintiffs in the case did not have the legal standing to be able to challenge the map. They sent that case back to Wisconsin to deal with accordingly, but basically that was Anthony Kennedy's last bite at this apple before he decided to retire. He decided not to bite the apple, and so the partisan gerrymandering cases live on. This ended up having a direct impact on North Carolina's case. And no, I don't think that's one of the plaintiffs in the cases. I'm just using the ping pong reference because this case is kind of ping pong back at various levels of the court system. Before the ruling last summer in Gill v. Whitford, a three-judge panel dealing with Rucho versus Common Cause had already decided that the case was that the plaintiffs should win because the congressional map was overly partisan. The General Assembly and its attorneys had urged the court not to rule, not to even take up any case until after the Supreme Court ruled in Gill v. Whitford saying, look, the Supreme Court is taking up this exact same issue, the same topic. There's no reason for North Carolina to have this case before Gill v. Whitford is decided. The three-judge panel said, no, this is important. We need to address this. They went forward with their case, ruled in favor of the plaintiffs and against the General Assembly. After Gill v. Whitford, once this case had been appealed back to the U.S. Supreme Court, the Supreme Court ordered the three-judge panel to take a look at the case again based on what it had just ruled on the standing issue in Gill v. Whitford, saying, look, we said these plaintiffs in Wisconsin couldn't bring this case. You've decided North Carolina's map is unconstitutional, but you need to now incorporate what we just said about whether the plaintiffs even have standing. So the three-judge panel looked at the case again and said, thank you, Supreme Court. We basically decided exactly what we decided the first time. We think these plaintiffs do have standing, and we still think this map is unconstitutional, overly partisan gerrymandering. So that's why the case got back to the Supreme Court, the ping pong there, and that's why we had the oral arguments on March 26th. We do expect a decision, as I mentioned, in June, and really it's going to come down, unless the case gets punted once again for some sort of technical issue or a standing issue. If there is an actual decision on the merits, we could end up with some judicially manageable standard by which the justices decide, courts in the future will be able to decide whether partisan gerrymandering is too partisan and thus unconstitutional, or we could have a decision that this is a political question, courts are not going to be able to decide this. The Supreme Court could wipe its hands of partisan gerrymandering cases altogether. The reason I put up the picture of the newest Justice, Brett Kavanaugh, is because he could be the swing vote going either way, either going with the bloc that says that there is a judicially manageable standard and we're going to apply it now to not only North Carolina's case, but future cases going forward, or he could side with the other bloc and say this is something the court should not deal with ever again in the future. How Justice Kavanaugh is going to come down on this is a bit of an open question. I'll get to in just a bit the fact that some people kind of figured he's going to definitely go with the conservative bloc. Partisan gerrymandering cases are done completely at the U.S. Supreme Court level. But some of the things that came out of the oral arguments last week suggest that that is not necessarily true. During his questioning of the attorneys, both in this case and the Maryland case that was referenced, that was right after this one, the same day, there was some suggestion from Justice Kavanaugh that he would be interested in leaving this issue to the states, saying that, you know, there's some activity going on in the states. That was something that also Judge Neil Gorsuch had referenced. And so perhaps that's where this should be decided and not by the federal judiciary. But he also did not dispute the notion that extreme partisan gerrymandering is, in his words, a real problem for our democracy. You're actually, in a bit, going to hear him use those words, and you'll hear the context for it. And so he also, in the Maryland case, brought up this notion that perhaps the Equal Protection Clause of the Constitution would call for something like proportional representation. And for those who aren't familiar, proportional representation is a system that some other countries have where people go and they vote for a legislative office, and you're not really voting in a contest of candidate X against candidate Y. You're basically casting your ballot for the party you like, and the party ends up getting seats in the legislature based on the percentage of total votes they get. We don't have proportional representation in the US or in North Carolina. We elect people by districts. It's one of the reasons why gerrymandering isn't the only reason for the large splits you sometimes see between a total popular vote and the way that the seats shake out in the actual legislature. So we're going to hear a little bit about what was discussed. The first segment you're going to hear, if this plays correctly, and if not, I'll blame my technical advisor, who is me. So the first one is an interaction between Justice Kavanaugh and Paul Clement, former U.S. Solicitor General, who is working on behalf of the North Carolina General Assembly in this case.
On proportional representation, can I ask a question? Which is, first, isn't proportional representation a judicially manageable standard?
Well, it's a difficult standard. It would require answering some questions about where it's baseline, what elections do you get the baselines from, but it could be manageable.
And the second is, why can't the Equal Protection Clause be interpreted to require something resembling proportional representation?
Because it's entirely ahistorical, and keep in mind, the framers gave state legislatures the choice of ensuring proportional representation by having statewide elections, but they also gave them the choice to districts, which is fundamentally inconsistent with that.
Okay, so that was one interaction. And for those of you who are very interested in this topic, I would recommend going and listening to the whole thing. It was actually pretty fun. About 70 minutes. You'll hear all of the justices except one ask a question. Who can guess who didn't ask any questions? Clarence Thomas, of course. He was the only one who didn't ask any questions. Everyone else did, and you could kind of sense where they came down based on the questions that they asked. We're going to see now if this will advance. Good. All right, so this next interchange is between Justice Kavanaugh and Allison Riggs, who was one of the attorneys working for the plaintiffs in this case. She's with the Southern Coalition for Social Justice.
I took some of your argument in the briefs and the amicus briefs to be that extreme partisan gerrymandering is a real problem for our democracy, and I'm not going to dispute that, and that the court, even though it might be a problem to get involved in all these cases, should, in essence, recognize the emergency situation from your perspective. But what about, to pick up on something Justice Gorsuch said earlier, that there is a fair amount of activity going on in the states on redistricting and attention in Congress and in state Supreme Courts? In other words, have we reached the moment, even though it would be have we really reached the moment, even though it would be a big lift for this court to get involved, where the other actors can't do it?
The North Carolinian plaintiffs in front of you can do nothing to solve this problem. But
I'm thinking about more nationally. The amicus briefs are certainly referencing a problem in many states. And the idea, I think, in the briefs is this court and this court alone can step in. And there is a fair amount of activity going on in the states, recognizing the same problem that you're recognizing.
So anyway, two different thoughts coming out from Brett Kavanaugh, asking whether proportional representation could be a judicially manageable standard, but also asking the attorney for the plaintiffs whether this is something that really should be addressed now, or should it be left to the states. Now, if the Supreme Court does reach a decision, either with the manageable standard or saying this is a political question, we're never going to take up this issue again, at least as long as we have 5 votes in that favor, the debate over partisan gerrymandering in North Carolina will be over, right? By your laughter, I could tell. You know where I'm going with this. No, not at all, because there is in state court, part 2 of the presentation here, the case Common Cause versus Lewis. Now, Rucho's name might have been on this case again, but he was out of the General Assembly by the time that this that this case was filed. So instead of having the top name be Bob Rucho, the Senate leader of the redistricting process, instead this time the leader of the House redistricting process, David Lewis, you see their picture, is named in this case. Common Cause v. Lewis was filed in state court challenging North Carolina's state House and Senate maps, so not the congressional maps, but the legislative maps, also on partisan gerrymandering issues. This suit was filed exactly 1 week after the November election. We're going to get to why that might be significant coming up in just a bit. And I think the other distinctions between this case and Common Cause v. Rucho are also important to mention. As I alluded to, this is dealing with the legislature, not congressional maps. This is also a suit that's filed based on the North Carolina Constitution, not the federal Constitution. And that's a reason why it's staying in state courts. It's going to be limited to state court. The General Assembly wanted to have this case moved to federal court, took it before District Judge Louise Flanagan, who, for those of you who are wondering about the political affiliation, she was appointed by George W. Bush. So not necessarily someone who would be inclined to be against the General Assembly just based on partisan on a partisan basis. But Judge Flanagan said, no, this is a case that's dealing with the state constitution. It belongs in state court. It does not belong in federal court. So it's likely that this case is going to stay in the state court. And Common Cause v. Lewis has 3 alleged violations. I'm not an attorney, and I'm not going to pretend to be one, so I'm not going to get into the details. But basically, the case challenges the North Carolina legislative election maps based on 3 potential violations of the state constitution, one being the Equal Protection Clause, and those who are arguing in favor of the plaintiffs and against the maps say that the state constitution offers a broader protection than the federal constitution, and that's one reason why the Equal Protection Clause comes into effect. There's also a potential violation, according to the plaintiffs, of the Free Elections Clause, and that's the clause saying that elections will be free, and the argument is that, well, this gerrymandering is such that it's disadvantaging people based on their political beliefs. It's not really a free election. And then there's also the argument that the partisan gerrymandering, according to the state constitution in this claim, would violate Democrats' freedoms of speech and assembly. Why pursue this case in a state court and not just continue to challenge the legislative maps in federal court, which previous maps have been challenged in federal court, even though they were legislative maps? Well, I'm sure that the plaintiffs do actually believe their case and believe that these violations occur. But I'd also suggest there could be another factor involved here. Brett Kavanaugh, I referenced that some people thought that Brett Kavanaugh could be the swing vote, and there are some, and I know that at least one major political figure in the North Carolina Democratic Party believed before the oral arguments that Brett Kavanaugh was going to side with the conservatives, that partisan gerrymandering cases would be forever over in North Carolina based on the federal court system. That person was Attorney General Josh Stein. He was moderating a panel I sat on and basically said these partisan cases in the federal courts are over. Kavanaugh's going to go with the conservatives. That's why you're seeing cases filed now in state court. So if Brett Kavanaugh generated concerns among the gerrymandering foes that they might not be able to get the type of hearing they wanted on the federal courts, perhaps the situation at the state court level is a little bit different. They might have been heartened by the election of Anita Earls to the state Supreme Court. For those of you who are unfamiliar, now Justice Earls spent much of her career fighting Republican election maps. That was one of her main jobs. She defeated Barbara Jackson in last November's election for the Supreme Court, thus building upon what was already a 4-3 majority for Democrats on that court to make it 5-2. The suit, Common Cause v. Lewis, was filed exactly 1 week after the election that put Anita Earls in that office. And then that's not all. After this happened, of course, the Chief Justice of the Supreme Court, Mark Martin, decided to retire after 20 years on the bench, become the Dean of the Law School in Virginia. So we also now have a new Supreme Court Chief Justice, Sherry Beasley, who had been a long time Associate Justice, now the Chief. She's a Democrat, and because she was elevated by Governor Roy Cooper to become the new Chief Justice, that freed up a seat on the state Supreme Court. Republicans urged Governor Roy Cooper to maintain the partisan balance on the Supreme Court, saying, look, there's a 5-2 balance on this court now, 5 Democrats, 2 Republicans. You ought to put another Republican on the court. Roy Cooper took that advice, put it where I'm sure he wanted to put it, and made another choice, which was that the 7th seat on the court was filled by Mark Davis, another Democrat. So now our state Supreme Court has 6 Democrats, 1 Republican. For those of you who haven't followed it that closely, as recently as 2016, Republicans had a 4-3 majority on this court. It's now a 6-1 Democratic majority thanks to 2 elections and a couple of appointments. Now, I don't want to say that the new state Supreme Court is guaranteed to rule in favor of the plaintiffs, one of whom, beyond common cause, is the North Carolina Democratic Party. They are also plaintiffs in this case. I'm not going to say the state Supreme Court is going to do this. There's enough evidence from the state Supreme Court's actions in recent years to show that they don't always rule in a partisan way. But I think it is safe to say that this court is not going to be inclined to rule in a way that is designed to favor Republicans. I think you can safely say that they're not going to say, well, this is the way that's going to help Republicans. Let's go that way. That, I think you could be fairly safe to say. It's also important at this point not to get too far ahead of ourselves. This case is likely going to get to the state Supreme Court at some point. But before it does, it's going to go to a 3-judge panel led by Judge Paul Ridgway of Wake County. This is the same 3-judge panel that's dealt with several other redistricting challenges in North Carolina. And what ends up going to the state Supreme Court is going to depend quite a bit on what this panel decides to do. If this panel rules in favor of the plaintiffs, it would be very easy for the Supreme Court to basically say, yeah, the 3-judge panel got it right. If this panel rules against the plaintiffs and in favor of the General Assembly, then the Supreme Court will have to more actively explain why the 3-judge panel got it wrong and why the plaintiffs should get it right. If you're interested on the 3-judge panel, there are 2 Democrats and 1 Republican. So if the 3-judge panel ruled in favor of the General Assembly and the Supreme Court ruled the other way, I think a lot of people would look at it and say it really is a sign of partisanship playing a role in the ruling. But as I said, we don't know how this panel is going to rule. We don't know how the Supreme Court would rule. We do know that this panel decided, and I think wisely, not to hold a trial on this case until after the U.S. Supreme Court rules in the federal case. The suit, as I mentioned, was filed a week after Election Day. Back in February, the 3-judge panel decided it was not going to hold a trial in this case until July. So July 15th is the start date for the Common Cause v. Lewis case, so they will know by that point how the U.S. Supreme Court has ruled in Common Cause v. Rucho. All of that, of course, is going to be very interesting to follow. And then I'm going to move to the third part of the presentation, which will be basically the coda. It's not going to be as long as the first 2. But that is, as all of this activity is taking place with the court process, there's also a push to take the courts completely out of this process through some sort of redistricting reform measure. Person pictured here is Representative Chuck McGrady, who is a Republican from Henderson County, taking the lead on many of these issues. He has a bipartisan group working with him on this. And there are a couple different ways that Representative McGrady and his colleagues are pursuing this. One is House Bill 69, which was filed on February 13th. The lead sponsors were McGrady, fellow Republican John Hardister from Guilford County, along with two Democrats, Robert Reeves and Brian Turner. The bill at this point has 62 co-sponsors, so more than half of the State House has signed on to this bill, which means if everyone's stuck with it and it ever got to a floor vote, it would get through the House. But of course, things can change. This is a bill that would set up a nonpartisan redistricting commission to move forward with future redistricting in North Carolina. Second piece of legislation filed 1 week later on February 20th is House Bill 140, the FAIR Act. This time the sponsors are McGrady, Hardister, and Reeves. Substitute out Democrat Brian Turner for Republican Sarah Stevens. So largely the same primary sponsors, though not entirely. And this one also has more than 60 members of the House who have signed on to it, giving you the notion that if it ever did get to the floor and all of those people stuck together, it would be able to pass the State House. This bill, House Bill 140, would change the law regarding redistricting, but would also put a constitutional amendment on the ballot in March 2020 so people could put redistricting criteria into the state constitution. Now, I actually have a copy in front of me, and people can grab it afterward if they like, of the 7-page FAIR Act. Some of the things it talks about are making sure that as you're redistricting, you don't take into account the political affiliations of registered voters, previous election results, the address of an incumbent or any declared candidate, demographic information other than what's required by to comply with the federal law, which is you have to have some racial data to make sure that you aren't involved in a racial gerrymandering. And one other factor is any other data that could identify with reasonable certainty the voting tendencies of any group of citizens. There are also the provisions that this has to be compact, has to be contiguous, and that you don't divide counties any more than you have to, which was something that came out of the 2002 Stevenson redistricting ruling. The last time the Democrats ran the redistricting process and the Republicans were the one challenging the maps. No hearings have been held yet on either of these bills, and I'm not certain that there's any timeline for that. The leadership in the State House has not suggested any interest yet in moving forward with that, but it's something that could happen this year. There is going to be a push, especially among those who look at the other pieces of data that I put forward to you about where things stand with the courts, who are saying to legislators, look, you can give yourself an insurance policy here against a court decision you might not like by addressing redistricting reform in one of these ways. And then the big question mark, of course, I put a question mark on it after the word, is the Senate. If the House decided to move forward with this, would the state Senate do anything on this? State Senate Leader Phil Berger has suggested no interest in dealing with any sort of redistricting reform. If the House were to address this and the Senate did not, tough, it wouldn't pass. So I think I will go ahead and wrap up the formal piece right there, and we have plenty of time for questions. Thank you. Sure.
So you listened to the entire oral
I did.
argument, okay, and I'm sure that more popped out at you other than those two clips that you chose. What was your sense of the justices and the arguments, I think in particular for this group, the arguments for those who believe that drawing with a political advantage is unconstitutional? Did it become clear why they thought that?
One of the first statements that came out from Paul Clement, the attorney working for the General Assembly, was, look, this is something that has been part of our political process for centuries. The framers understood it. In fact, the very end of the hearing was his rebuttal period, and he said, look, the framers knew all about this. James Madison was targeted by Patrick Henry for what was not yet called gerrymandering, but was exactly gerrymandering. Alexander Hamilton wrote to John Jay and said the Federalists should gerrymander some districts to help the Federalist cause, and Jay told him it was a bad idea. So Clement was saying, look, all three authors of the Federalist Papers knew about this. When the document was put together, the framers of the Constitution could have said that the courts will oversee this, that we know that gerrymandering is going to happen, so the courts are going to oversee this process. They didn't. What they decided was that the state legislatures should be in charge of all of this process of determining how the elections are held with oversight from Congress, not the courts, oversight from Congress, because Congress has the ultimate authority to decide who it will and won't seat. So if it sees that there's some terrible process coming out of the states, that it could decide not to seat someone. We've seen some evidence of that debate outside of the context of gerrymandering, but in the whole 9th District debate, there was, if Mark Harris had been certified as the winner in the 9th District, there was some question about whether Congress would have gone along with it. This is the same type of thing playing out. Now, that was the last thing that Paul Clement said. This is a long way around to get to your question. But he started to make this same argument at the very beginning of his presentation, and Justice Sonia Sotomayor cut him off and said, wait a minute, that ship has sailed. When we ruled in, I believe it's Baker v. Carr, one person, one vote, what the framers thought about how this process moves forward was moot. It was we decided one person, one vote. That changed the whole picture from what the framers had decided. And so now it's all about making sure that you're not diluting anyone's votes, that you're not unfairly targeting someone or discriminating against them in an unconstitutional way. And so that was one of Sonia Sotomayor's statements. Ruth Bader Ginsburg didn't have that many questions, but she did come out and ask Paul Clement, the General Assembly's attorney, why it would not be a violation of the Equal Protection Clause if someone's vote had been diluted by gerrymandering, that if your vote didn't count as much as someone else because of gerrymandering, why would this not be a violation of the Equal Protection Clause? Stephen Breyer didn't really give you a philosophical argument, but Breyer was all about the practicality. Breyer said, look, some of these gerrymandering cases, they're just egregious. He said, including perhaps this case. He said, I'm just trying to come up with an easy standard that is not going to trip up any judge, that everyone's going to understand. And so how about this one? He threw out a trial balloon that one party wins a majority of the statewide vote, and the other party ends up getting more than 2/3 of the seat. It's 2/3 of the seats. He said, wouldn't that be a standard that we could live with, that you're saying that it's so egregious that even though one party gets more than half of the votes, the other party gets more than 2/3 of the seats? Isn't that something that could be judicially manageable? Paul Clement danced his way around that one and said, no, that's not what people are guaranteed. I'm trying to think those three. And then Elena Kagan basically took issue with what Clement was talking about with the when he was speaking against the standards that the plaintiffs had put forward.
You know, we keep hearing about Chief Justice John Roberts now being a so-called swing vote. Do you have any sense of where he is on these questions?
He basically played devil's advocate with both sides. I did not get the sense that he was definitely in favor of one camp or the other. He cracked a couple jokes. One of the things I referenced, that this door to having partisan gerrymandering be controlled by the courts really opened with the '86 case of Davis v. Vandermeer, Roberts asked Paul Clement at one point, if we rule in your favor, do we have to overturn Vandermeer? And Clement said, well, it depends on how you rule. And Roberts said, well, if we rule in your favor, do we have to overturn Vandermeer? Thus prompting a lot of laughs. And Clement still said, it depends on how you rule. He said, if you throw it out in terms of standing, no, it wouldn't do anything about Vandermeer. If you rule substantively in our favor, yes, you basically would have to throw out the ruling in Vandermeer that some level of partisan gerrymandering could be unconstitutional. Roberts also, when the plaintiff's attorneys were up, had sort of the devil's advocate style questions, but he was on the court the last time this came around and seemed to be in the conservative bloc, so that could give you a hint, but he didn't say one way or the other. Other than Clarence Thomas, who said nothing, the two justices who clearly seemed to have a problem with trying to find a judicially manageable standard were Sam Alito and Neil Gorsuch. Both of them basically just hammered back on this notion of how are we going to determine what is a proper baseline? I mean, if you're going to say something is too partisan, what's the proper baseline? And is there anything else other than proportional representation, which the Supreme Court has consistently said we don't have proportional representation. Even Allison Riggs, the attorney for the plaintiffs, admitted when asked that we don't have proportional representation. So Alito and Gorsuch seem to be very much critical of this whole idea. One can assume, because he has cited this way before, that Clarence Thomas is. Roberts, if you had to put some money down, I would guess you'd bet that he'd be on that side as well, although it's not as clear. And Kavanaugh was a little bit more of a wild card in the sense that he did mention this idea that perhaps the Equal Protection Clause requires something like proportional representation. I don't know if that was just an intellectual exercise. He wanted to hear what the attorneys on both sides would say, or if that's how he's really thinking. But that definitely could be where he's coming down. But he also, as you heard, suggested that perhaps this is something best left to the states, that there's a lot of activity going on in the states, and perhaps the federal courts ought to wash their hands of this. Yes, sir. And then we'll get to John.
Make any comparison between the state case here and what happened in Pennsylvania with their case, and whether there's, I'm not sure up on that, but that whether their constitution was similar and whether the case was brought in a similar fashion?
Yeah, I don't know how similar the constitutions are, which would definitely determine this. As I said, in our case, the plaintiffs are arguing three different sets of concerns that they say that the partisan gerrymandering violates our state constitution, and I'm not sure whether the Pennsylvania case, or the Pennsylvania Constitution is enough in line with ours that there would be an apples-to-apples comparison. I think the reason why the prospect of the state case is a little bit more dicey for the General Assembly than it has been is the changing makeup of the court. And not even necessarily because of the partisan makeup. I mean, you could easily say, okay, there's 6 Democrats, 1 Republican, they're going to go with the Democratic side. You know, I don't want to get and say that that's going to be what happens. It could be because of different philosophies. I mean, Anita Earls, a large part of her career was fighting these election maps. My guess is she is going to be very much in tune with whatever argument Common Cause puts before her about why this violates the state constitution, because it's the type of argument she made when she was an advocate on the other side. Where Sherry Beasley or Mark Davis come down, it's going to be hard to say. As far as the other justices, Robin Hudson, I don't know. Sam Ervin IV, Jimmy Ervin, has often over the past couple of years ruled along with the Republicans, sometimes in 4-3 majorities against the Democrats. But now that he would be sort of off on his own island with Paul Newby, would he do that? Or is he going to try to go along with the Democrats? It's hard to say. John. Right.
And the Fair Act, which doesn't deal with the commission but with legislative.
Right.
You're describing those two, and I think you've written about this before, Mitch, but what you call a strong commission, a commission that actually draws the maps, is higher than it would have been a couple of years ago because the elections were more disputes.
Yeah, I think you're absolutely right about that, that the idea of setting up new commissions, legislators are going to be gun shy about that, not just because of the Board of Elections, which is a good, apt example, but also the court cases they've lost, in which they've tried to set up new groups, in which the legislature had a major role in setting the membership of those groups. Governor Cooper took them to court and had, actually this started back with Governor Pat McCrory, and Governor Cooper piggybacked on this to say that no, the governor needs to have a controlling interest in the membership of these boards. I don't think the General Assembly is interested in putting together a new commission that might then end up being put under the governor's wing, and probably wouldn't be interested in a new commission in general. Yeah, I'm glad you referenced the fact that the FAIR Act does things in a different way, because I didn't really mention that, but the FAIR Act, the way districts would be drawn would be through legislative staff. The Legislative Services Commission would set up a process, and then there would be a temporary advisory committee made up of appointees from the Senate and House majority and minority leadership. So there'd be members, bipartisan, that would serve as an advisory group for staff who would actually end up drawing the maps. All of these maps would end up having to get voted on one way or the other by the General Assembly, but the processes discussed here would take them out of the role of actually drawing the maps themselves. And there was
This question here, and then I've got a question for you.
okay, great.
The only way to really have a nonpartisan map is to just have a computer generated, start in one corner of the state, make it as compact as possible to have one man, one vote, or however we do the districts, and just go across the state, up and down, and make them and not have any political interest in it. And the second thing is, as far as congressional or even state maps, doesn't the Voting Rights Act presuppose gerrymandering? Because it is gerrymandering. And we ran into that in Guilford County. We got involved in redistricting and also going from 11, we had the largest commissioner, we had 11 commissioners, most of them are 5 and 7. We did that. We drew the most compact maps we had, and the Democrats came back with districts that were not competitive. People would have been running unopposed, and they had 2 of the districts had point contact. I mean, it's just ridiculous.
Yeah, back to the first part of your question, computers would be able to generate a better map, and then the second part of your question actually leads into why we don't have them, because of the Voting Rights Act provisions that have said for a number of years that you have to have districts where there's a need for them that represent a majority-minority interest. Now, the complicating factor there is that for years and years, the states that had to do this process, including North Carolina, were relying on data that was set from the Voting Rights Act in the mid-1960s. And there was a court case a few years back in which the Supreme Court said, this is old data, it's never been updated. We're not going to enforce forcing the states to comply with Voting Rights Act data that is decades old, in which we haven't gone back at any point, meaning Congress. Congress hasn't ever gone back at any point and seen which of these places still have the racially polarized voting that would require it. So it's been in limbo because Congress has, since that ruling, has not decided to go back and update the Voting Rights Act. And that's one of the reasons why the current congressional map that we have, according to the legislature, didn't take race into account at all. They said, when they drew the maps that we've used in 2016 and 2018, look, the courts have told us that we engaged in racial gerrymandering, so this time around, we're not going to use race at all. And that's when David Lewis came up with his now infamous statement that this was all based on partisanship because he drew a map that would elect 10 Republicans and 3 Democrats because he couldn't do one that would do 11 Republicans and 2 Democrats. That there was race. The whole point of that was not to say, ha ha, we're messing with you Democrats and you're only going to get 3 seats. It was, we're not doing this based on race. It's entirely politics. We built in as a criterion, try to elect 10 Republicans, try to elect 3 Democrats. And so the Voting Rights Act piece is muddled right now because there is no current active standard that either North Carolina or any of the other states that have to comply, there's no active standard for them to meet at this point. And so one of the things you did hear from Democrats when that 2016 congressional map came out was, wait a minute, you're not taking account of race at all? You've got to take account of race in some respects. And the General Assembly said, no, wait a minute, we were just told we did a racial gerrymander. We're not going to do that. And there's actually an interesting argument when Tom Farr was up for the appointment to the federal court and was testifying. He was asked about this issue, and he had an interesting take on how the courts had ruled on the racial gerrymander, and that was that the courts have told North Carolina that you only take race into account if there's a history of the racially polarized voting with the majority bloc voting to block a minority candidate from being able to get into office. And if you don't have a record, legislative historical record of that, then you shouldn't take race into account. I don't know if that particular interpretation is going to stand, but it's certainly one that's in the mix right now until either the courts or Congress does something about the Voting Rights Act.
Our final question today is going to come from Twitter. By the way, we live tweet these presentations at John Locke NC, and today, courtesy of Dan Way from Carolina Journal, Dan is making a tweet here. And so this is how it goes. Dan tweeted, Mitch tells Locke 2 pieces of redistricting reform legislation have been introduced in the legislature, but no hearings have been set as of now. We got a reply from former North Carolina Supreme Court Justice Barbara Jackson, who is following this conversation with this question. Perhaps they're waiting on the Supreme Court ruling as well? Question mark. Likely late June if history tells us anything. What do you think, Mitch?
Yeah, that's a good sense of things based on Justice Jackson. My guess is no one within the General Assembly wants to do anything before they know how the Supreme Court is going to react. And my guess is if they still plan to be in town, and we can hope that they'll be gone by then, but my guess is that they still plan to be in town, they really won't want to do anything until the state case is resolved, and that won't happen until July.
Okay, so we will reply back to former Justice Barbara Jackson that you answered that question. Okay, and that's just a good reminder. We've got a lot of folks who are following us on Twitter. 11,000 people follow our Twitter feed. We hope that you are one of them, at John Locke NC. Mitch Kokai, thank you very much.
Thank you.